Okay, go ahead and set it up for the state on the bond hearing today.
Yes, Your Honor. Katie Magyar here for the state. This is the state of Georgia versus Jesus Monroy, quasi-criminal number 24-B-02967-5. The defendant was arrested on July 17th, 2024 on warrants for malice murder, felony murder, feticide, aggravated assault, and false statements and writings. We had a preliminary hearing on August 23rd of this year, Your Honor. The case was bound over. We are scheduled for a bond hearing today. I'll go ahead and give the brief facts, or proceed by proffer.
Ready to proffer, Mr. Gelfond.
Hey.
And before we proceed any further, I did indicate before the meeting that there's a Rule 22 that I signed to allow press to record this hearing. Any objections to be heard before we begin from the state?
None from the state, Your
From
Honor.
the defense?
No, Your Honor.
From anybody else in the courtroom? None noted, the Rule 22 stands. Proceed with the proffer of facts, Ms. Magyar.
Yes, Your Honor. On July 14th, 2024, Mia Campos' family lost contact with her. The last anyone had seen her was about 10:30 p.m. She was 16 years old. Concerned that she had not returned or was responding to messages or phone calls, they contacted her friends as well as the defendant, his family. The defendant is the father of, or is the father of Ms. Campos' unborn child. That is also deceased, Your Honor. They eventually utilized the Life 360 app to try and locate her. Her phone pinged in the wood line just outside of her neighborhood. The search party set out. The defendant, along with Ms. Campos' father, located her deceased body. They brought her out of Woodline up to the road. The police were called. Mia's phone was found in her pocket. While on scene, the defendant was hesitant to tell officers how he knew Mia. They eventually were able to, he eventually told them he was the father of her unborn child. Officers spoke with other people there. They also spoke with him again. He stated he had not spoken or communicated with her since about 8 p.m. that night. Officers spoke with Mia's family and friends who were there. Several reported that Mia had told them she was going to meet the defendant at the front of the neighborhood. There were Instagram messages with one of those friends where Mia told this friend that she was going to meet the defendant. The last message that person had from Mia was that she was scared. As I stated, Mia's phone was located in her pocket with her parents' permission. Officers examined her phone. They located a text thread between Mia and the defendant that did end around 8 p.m. However, officers also looked through her other apps and located a video on her phone that was a screen recording of her phone scrolling through text messages. It was the conversation with the defendant. However, this conversation continued on where the defendant asked Mia to meet him at the front of the neighborhood. He also told Mia to delete the text messages so that no one would read them. Jumping a little bit ahead, later on, when a full extraction was done from Mia's phone as well as the defendant's, officers were able to piece together that conversation from their separate phones to show that that video screen recording was accurate as far as the phone records go. An autopsy was completed. It was determined that Mia's cause of death was asphyxiation due to constriction of the throat, therefore strangulation, Your Honor, in the manner of death, homicide. The autopsy also revealed that Mia's unborn child was healthy, on track for gestational age, and was viable at that point. Officers later interviewed the defendant more formally. He maintained he had not communicated with Mia since 8 p.m. The night she was found. The defendant maintained he had his phone all day. No one had access to his phone, and he had not left his home that day. The defendant brought up that the home that he shared with his parents had cameras. Officers could check. It was noted that his father was the only one who had access. However, again, after the full extraction of the phone, officers located a text message conversation or a conversation between the defendant and a friend about a month before the incident where he indicated that he had access to the cameras, he could turn them on and off so that person could come onto the property. The defendant was arrested first for false statements. based on his statements to police that he had not communicated with Mia since 8 p.m. that night. However, based on the screen recording and statements from her friends that she had communicated with him past 8 p.m., he was arrested for those. Statements. A search warrant was obtained for the defendant's phone as well as cell tower data. Officers obtained timestamp GPS coordinates from the defendant's phone for the night of the incident. As I said, they were time-stamped and they could follow the coordinates from the defendant's home to the location where Mia's body was found at the time, around the time she disappeared, before anyone was searching for her or called the police. Officers also found messages from the defendant to 2 other females that contained photos of the patrol car's blue lights at the location, with him telling the females that he had been involved in a drunk driving accident and was in trouble. However, he told them he was just joking about that later. Your Honor, as I stated, the cause of death was strangulation, manner of death homicide, the fetus was viable. So those are brief facts in the case. The state is opposed to bond. We do believe the defendant is a flight risk. We received several letters from defense, letters of support, several of them, over a dozen, and many of them come from the defendant's relatives living in Texas. So he does have ties outside of the state of Georgia. So we do believe he is a risk of flight. We believe he's a risk to the community. This was a premeditated, heinous act that was committed up close and personal. This was a pregnant teenage girl that he strangled to death. So if he's willing to do that, Your Honor, we do have concerns for the safety of the community. We also are concerned about a risk to intimidate or influence witnesses. He already told the victim before he killed her to delete the text message evidence of their conversation, that he was even going to meet her, showing, as I said, the premeditation and a desire to alter or get rid of evidence. He does know who those civilian witnesses are that made the statements against him, as they were related to Mia and or her friends. So the state is opposed to bond. Mia's family, as Your Honor can see, a lot are present in the courtroom today. Her father, Edward Campos, is here and would like to make a statement to the court whenever the court is ready to hear from him.
Okay. I think statements are best had before I turn it over to counsel, so I will hear the statement from him at this time.
Mr. Campos, will you come up? And is the podium okay, Your Honor?
Yes, please.
If you raise your right hand. Do you swear affirm the truth do you swear affirm the testimony you shall give in the following proceeding is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, what is your name? Can you please state and spell it for the court reporter?
My name is Edward Campos. Last name is Campos, Campos. And just I'm here to represent my daughter. And I beg you to reconciliation the bond, because I'm afraid that, if you put a bond on him, he might run to Mexico or Texas, because, you can see to my left, you can see to my right that the people we got. And that's all I can ask you to reconciliation the bond for the safety of my family and my daughter.
Thank you, sir.
Thank you, Your Honor.
Anything else from the state?
Just argument at the end. Your Honor.
Appreciate it.
To you, Mr. Delphine.
Thank you, Judge. I do have one witness I'd like to call.
That's fine.
Enrique Monroy.
Come forward, please. All the way to the witness stand, or is it going to be short in the?
If he can come to the stand, Judge.
All right, all the way up, sir. But go to the corner of the courtroom over there and make your way up and get situated in that chair. Swear your witness, please.
Mr. Monroy, would you raise your right hand? Do you swear or affirm that the testimony you will give before the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you, sir. If you would, tell the judge your name.
My name is Enrique Monroy.
All right, and how do you spell that?
Enrique Monroy. Monroy.
And how are you related to the defendant, Jesus Monroy?
He is my brother.
All right, I would like for you to tell the court where your brother, Jesus Monroy, lived prior to his arrest.
He lived off of 2899 Monroy Road, Snowville, Georgia.
All right. Is that in Gwinnett County?
Yes.
All right. And who lives at that home?
At the home is my parents, me personally, and 3 other siblings.
Okay. So your parents, who are your parents?
Jesus Monroy and Juan Valdez.
All right. And you also have 3 siblings apart from Jesus
Yes.
that live there as well.
Yes.
All right. And how old is everybody, the siblings there in the house?
The oldest one apart from me is 17, Omar Monroy. Following that is a 14-year-old, Janique Monroy. And following that is 7-year-old, Diego Monroy.
All right. And if you would, because you've said their names, if you could spell those just for the court reporter, make sure she gets it down right.
The 17-year-old is Omar Monroy. And the 14-year-old Yannick is Yanik Monroy.
Okay. And you said Diego?
Diego.
Okay. And
It's Thiago.
okay. Thank you. How long has your family lived at that property?
Approximately 7 to 8 years.
Okay. And how long have y'all lived in Gwinnett County?
To the top of my head, 14, let's see, 15 years?
Okay.
Off the top of my head, I can't remember.
I understand. Did Jesus grow up here in Gwinnett County?
Half his life.
Half of his life.
Yeah.
Okay, I understand. You go to high school in Gwinnett County.
Yes.
Where do you go to high school at?
Self-Net High School.
Okay. And then, do y'all have, you talked about your immediate family that lives here in Gwinnett. Do you have other family that lives around the area?
Around the area, North Carolina, but we don't interact too much.
Okay, I understand. Do you have, what does Jesus do for work?
Landscaping,
All right. And who does he work for?
my father.
All right.
Jesus Monroy.
All right. So, does your father own a landscaping company?
Yes.
All right. And Jesus works for your family?
Yes.
And does he do anything else for work?
He's an electrician during the winter, since it's slow season for landscaping.
Okay. And you know, in a given week, how much work does he do?
Hours or?
Yeah. Is he working full time?
Yeah, full time.
Full time. Okay. And how long has he participated in working with your family's business?
Between 4 or 5 years.
Do you also work for your family's business?
Yes.
All right. And I neglected to ask you, but how old are you?
22.
22. All right. That you're aware of, has your brother, Jesus, ever been arrested before?
Never.
Has he ever been in any kind of trouble before?
Never.
There are some factors that the court has to consider in deciding whether to give him a bond. One of those, you probably heard some argument here in the court about already, is whether or not your brother is a danger to the community. Let me ask you, have you ever seen your brother act in any way that you would consider to be dangerous to the community?
Not at all.
Have you ever seen him be violent towards anyone?
No.
One of the other factors is whether or not he is likely a significant risk to commit other felonies. Right? He's charged with some, but if he got out, whether he would commit other felonies. Have you ever known your brother to commit any crime?
No.
Ever commit any felony?
Never.
Another factor is whether or not, and perhaps the main factor, is whether or not he is going to appear here in this court when he is required to do so by the judge.
We'll make sure he appears.
All right, you'll make sure. But let me ask you another question. Have you ever heard your brother talk about, in any way, his desire to, if he ever got in trouble, he was going to run?
No.
Since he's been in custody, have you talked to him?
I text him here and there.
Okay, through the jail thing?
Yeah.
Okay. Has he ever said anything to you about, if I get a bond, I'm out of here, I'm leaving and going to another country or anywhere else?
No, he has not.
Okay. The last factor is whether he is a danger to intimidate witnesses or tamper with evidence or otherwise obstruct the administration of justice. That's the official title of the factor.
Knowing him personally, he wouldn't.
He wouldn't personally. Why do you say that?
Just me knowing him, He's shy. He's not much of a violent person.
Okay. Let me ask you, has he asked you to contact any of the witnesses in this case to speak about the case in any way since he's been in custody?
No.
Has he said anything to you about, if I could only get rid of that piece of evidence, or if you could go hide this for me, or anything like that?
No.
Do you believe that if he was granted a bond by this court, your family could post a bond?
Yes.
All right. And you would, in fact, post a bond for him?
Yes.
Okay. And do you know how many people are here in support of your brother today?
Probably over 30.
Okay. I think those are all the questions I have for you, Mr. Monroy. Thank you.
Any questions, Ms. Pipeline here?
No questions, Your Honor.
You may step down, watch your step. Any other witnesses, Mr. Delphine?
No other witnesses, Judge. I do have what I've prepared, entitled here, Letters of Support, that I'd like to submit to the court. These are from family members and friends who are, as the state has said, are not in Georgia, but wanted to support my client and wrote letters. I provided them to the state.
Is it marked as an exhibit?
I can mark it as exhibit, Judge. I have not yet.
Okay, we'll do that. Any objection to reviewing the letters before ruling?
Yes, Your Honor, we did object until Mr. Delphine would be objecting in the email when he sent them.
And
I will be reviewing them over objection and just bring them forward.
And Judge, for the record, in this packet, there are 13 letters. On the second page, I've included an index of who wrote what letter, and they're numbered there for the court's review.
Any other presentation from you on his behalf today, Mr. Delphine?
I do have argument, Judge, if you want to review those letters first, or I can argue now.
Give me a couple minutes to speed read this, and I'll come back to you. You can have a seat.
Thank you, Your Honor.
Delphine, back to you, argument.
Thank you, Your Honor. Your Honor, I filed a motion for bond in this case. I will note that there are, I think, a total of 5 warrants. Procedurally, in timing, I guess the first warrant, which was for false statements, was taken out July 17th. He was interviewed on the evening of July 16th while at the Gwinnett County Police Department, where he voluntarily came. He was not in custody at that time, or at least under a formal arrest. He came voluntarily because Detective Ariaza with the Gwinnett County Police Department asked him to. He was interviewed. Detective Ariaza believed that he wasn't being truthful, and he was arrested on false statements at that time. It was about 6 days later when Detective Ariaza then took out the additional warrants for malice murder, felony murder, feticide, and aggravated assault. He has been held continuously, though, since July 17th of 2024. I want to start with, and I won't read my motion, but one particular cite from my motion, which is that the defendant's guilt or innocence of the underlying charge is not an issue at the bail hearing, especially since the defendant enters the proceeding cloaked with a presumption of innocence. That is my client as he sits here today. A presumption of innocence. He is not guilty, has committed no offenses, and has never committed any offenses before this. This is a young man who enters this court and in front of you with absolutely no criminal history whatsoever. He is 20 years old. He is a little, as we've been investigating this case and looking through it, honestly, Judge, we're quite taken aback a little bit about the sufficiency of the state's evidence. We had a preliminary hearing. I'm not rehashing that. And really, guilt or innocence is not a question for this court in establishing bond. I do think, because the state proffered some facts, it is important to note that really the only evidence the state has is that they believe my client's phone puts him in the area around the time of her death, and that there were text messages where they arranged to meet up that night that they believe were deleted off of the phone. Those are mere allegations. There is no physical evidence whatsoever. There is no camera footage that they've recovered. There is no DNA. There are no witnesses. There is no video. There is no anything else tying my client to this. More importantly, my client told them in the interview that there were cameras around his house and that they should go check them to verify his alibi. Detective Ariaza testified at the preliminary hearing that my client's phone was pinging in the woods at 11:09 p.m. Well, I did what the state did not do, which is go and get the video footage. And at that time, my client is on camera in his own home, not 7 miles away at the murder scene. This is not a trial, but Judge, there are serious issues with the evidence in the state's case. That being said, the sufficiency of it, or his guilt or innocence, is not really what this court is concerned with. It is primarily whether he will appear in court when required to do so. I called his brother to establish that my client has extreme ties to this community, and in fact no other ties to any other community. He has family other places like all of us do. And he has family in Texas, he has family in Mexico. His family is from Mexico, but he was born here in Gwinnett County. He is a United States citizen. He grew up in Gwinnett County. He went to South Gwinnett High School, and he lives in Snellville inside Gwinnett County with his mother, his father, and his 4 brothers. He works for their family business where he has worked. He works full-time for them. In the off-season, he also works as an electrician, apprenticing as an electrician for a friend of the family. He is a hard-working person, and from the letters that you can see from his family and his friends, he is somebody of impeccable character. These people, and many of them wrote in there, we know the charges against him. We acknowledge that he's charged with these things. In spite of all of that, our opinion of him remains the same. He is a man of character. The state has virtually no evidence other than what she has posited to the court. His phone pinged in the area, and he was supposed to meet up with her that night. They have no confirmation of that, and we have actual alibi evidence on the contrary, Judge. On the entire left side of this courtroom are his friends and family who have come to support him, to be here, to vouch for Mr. Monroy. He has ties to this community. The case law says that once we have established ties, it is the state's burden then to prove that he is a significant risk to commit additional felonies, or a significant risk to flee the jurisdiction, or significant risk to influence or intimidate witnesses, or significant risk to the community, a danger to the community. Ms. Feitnagar is asking this court to deny bond because she believes my client is a danger to the community. And her belief is, I guess, based on the nature of the case, that this is a heinous act for which they cannot really tie my client to, and he is innocent until they prove him guilty beyond a reasonable doubt. That if he's willing to do this to the pregnant 16-year-old mother of his child, what could he possibly do to anybody else? Well, his history in life establishes what he's willing to do, which is nothing. He's never been involved in a fight. He's never been arrested. He's never been violent. He's never done any of those things that would indicate future behavior. The nature of the charges aside, which are serious, and I feel for the Campos family losing their daughter in whatever way she was lost. But Judge, he's not a danger to the community simply by nature of the charges. If that were so, every murder case would automatically be denied bond, and the legislature could have wrote that in, that you're not ever eligible for bond if you're charged with murder, because the nature of it is so serious that that's a prediction of what you're going to do in the future. She also believes that he is not to have bond because he is a risk to flee the jurisdiction. She bases that on letters that I gave her, which say simply that he has family in Texas and family in Mexico. Well, certainly he does and has family in other places, like everyone. But they have not established a single factor, not one fact, not one argument to support that he will in fact flee. On the contrary, his entire life is here. Over 30 people have appeared here in court to support him. These are his family. These are his friends. This is his community support system who is here in court to support him. He works here. His family has a shop on their property in Snellville where he works doing landscaping businesses. He also was going out and doing landscaping jobs. But should the court give him a bond, he can still maintain a job even if you were to put him on house arrest. He can stay at his house. He can work for the family. He can be productive and support his family. He is not a risk to flee, and they haven't established anything. I have his passport. I am willing, I've told Ms. Feitnagar, I was willing to turn it over to the state to alleviate any issues that they had in his suspected flight from this country. I have it in court here today, and I'm prepared to turn that over. She also believes he's a risk to intimidate or influence witnesses. And as evidence for that says that he told the victim in the case to delete the messages on the phone. Judge, first of all, that is not evidence of him influencing or intimidating any witness in this case. That is at most what they might posit as evidence of guilt or consciousness of guilt in the case itself. But it is not any evidence of his willingness or ability to influence or intimidate witnesses in any way. They have not given one shred of evidence, not even argument, as to how that fact or any other fact goes towards my client's desire or likelihood or, as the law says, significant risk to do any of these things, much less intimidate any witnesses. The reality here is that my client was not in a relationship with Ms. Campos at the time, but they had an encounter. She got pregnant. She had a child. It's not even legitimated or any DNA proof that it's his, but he accepted responsibility, believing it to be his. He took her to appointments. The day before, on Saturday, he spent the entire day with her, driving her to the dentist and to the pharmacy, and drove her where she needed to go, and took her to appointments, provided for her, provided for the child, took her and made sure that all the things that she needed. He knew the family. Right? They were getting to know each other even more because she had gotten pregnant, and they were going to be in each other's life forever at that point. He was doing what was expected of him. He was doing what he should have done and was providing for her. At the time when the police found her body and Mr. Ms. Campos' father found her body, her family told the police they did not suspect him in any way. They did not believe he was involved in any way. In fact, after his arrest on the 17th, the Gwinnett County Police Department issued a press release saying they didn't suspect him in any way of being involved in her murder. There's simply no evidence that my client is a significant risk to commit any of the things that this court should consider. The nature of the crime aside, my client is a good candidate for bond. His family can and will post his bond. They are willing to ensure he complies with every recommendation of the court. In my motion, I've told the court whatever conditions this court wants to impose on him to ensure his return to this court, he is willing to do. That includes he's willing to be on house arrest. They're willing to pay for a GPS ankle monitor. They're willing for all stay-away conditions from every witness and her family involved in every way in this case. My client's past behavior is indicative of his future, which is nothing. He will comply with this court. He is from here. He's from Gwinnett County. He lives here. He's going to appear here in court, and he is not a significant risk of any of those factors, Judge. We respectfully request that the court set a bond in his case with whatever conditions the court is comfortable with. I have told his family that bonds in murder cases tend to be pretty high. They are willing to pay whatever it takes, Judge. I'm suggesting a $75,000 bond in his case to ensure his return back here to court. And certainly, Judge, willing to surrender his passport and submit to any other conditions that this court should impose. And we'll request bond, Judge.
Ms. Pike-Knight, you have further argument?
Yes, Your Honor, just briefly. I wasn't going to get into this, but since it was brought up by defense, the defendant was going to appointments, was helping provide for his unborn child, because when Mia's father and family found out she was pregnant, they wanted to press charges against the defendant because she was 15, or would have been 15 at the time of conception, while the defendant was 19, making that statutory rape charges. Mia begged her father not to press charges against the defendant, and he agreed as long as the defendant stepped up and took responsibility. So in doing that, he was seeking to avoid criminal prosecution. I would rely on my earlier arguments, Your Honor, that he is a risk to the community. As I stated, strangulation is an up-close, brutal way to commit murder. If somebody is willing to murder a 16-year-old heavily pregnant girl in that manner, he is a risk to the community. So the state would rely on its earlier argument and ask Your Honor to deny bond.
I hereby grant bond in the amount of $50,000. Special conditions of bond include that he have a GPS ankle monitor in place within 24 hours of his release. He's to remain at his address, which is his home address, to be included in the order. And he's only to leave for medical appointments and appointments with his attorney. He's otherwise to be on site of the residence. He's to have no contact whatsoever with any potential witnesses in this case. And the passport is to be surrendered to the district attorney before leaving court today. Those are the special conditions of probation. Do you have enough information to prepare the order, Mr. Delahunt?
I will, Judge, and on the record, I have a passport in my hand. I'm handing it to the state now, turning it over pursuant to the court's order.
For the record, done. Thank you. That concludes business. I do provide a proposed order on the matter.
I will, Judge.
All right, we'll be at ease for 5 minutes while
Your Honor, I did have one request that any
Yes.
violation of the house arrest be reported to the court in the district attorney's
Yes, if
office.
you'll include, make sure that it includes the information clause where the district attorney has the ability to get information about compliance. And if you'll just run the order by them so they have that, so that if there are any violations, we can take action. He's to comply with the court order, otherwise he forfeits the right to be free pending trial. Thank you.
Nobody moved but the victim's family. You can take the victim's family out.
Victim's